again thank Kim, Matt, and Dave for being here today. We did go ahead and give them some questions to start out with, and then of course, once we have time, we will have them answer any of your specific questions afterwards. So we're going to start off with Kim. She's going to talk about post and pre-settlement occupancy agreements and things that are going on with those. So Kim's going to start us off.
Okay, we have been advised that the Board of Realtors is going to be pulling pre and post settlement occupancy forms from your contract forms. And a caveat to that is that you might go to your settlement attorney and say, would you prepare this for me? Some will, some won't. Some will for an extra fee. Our firm has chosen to do it for an extra fee. Although if it requires negotiations, that would be something totally separate. My suggestion, and the suggestion that has been made, is that you pull a copy of the old form and keep it in your back pocket just in case. You know, work with your broker with regard to whether or not your brokerage will continue to allow you to prepare those, and if not, make sure that you get a hold of your settlement attorney far enough in advance to figure out who's going to prepare them for you.
I think I mean, you guys are an integral part of the transaction, and you just cannot shelve that away as if you're not going to be part of that transaction. If you do, you're going to find some stalling near the tail end of the settlement procedures where you're probably going to have delays, and you're going to get aggravation, because where you get aggravation is when expectations aren't satisfied. So people become aggravated because now we can't get to the finish line because nobody wants to deal with this post-occupancy or pre-occupancy agreement. If we're involved, I'm probably going to use the old form that you guys have. And if they say prepare it, I'll say fill in the blanks, guys. Fill it in and let the consumers fill it in. They're going to look for somebody to lean on, though. They're going to look for somebody to lean on. And then the truth of the matter is, if you say both you guys go get lawyers to help engage that document, then you're going to be looking at delays that just become quite unacceptable. So it's tough. I mean, you know, the finish line is what everybody's looking for. And if you want to push that document aside and say, we're not going to touch it, like I said, we'll just use your form and let them fill it out. Again, if it's a pre-occupancy, it's going to have to be done well before closing. If it's a post-occupancy, it might happen at the last second, kind of like a walkthrough form. So, I mean, it's something, you know, if indeed you guys have decided that's how it's going to be, you just got to be prepared to be even more engaged in at least verbal communication to put your people at ease that it'll be okay. But neither one is preferable. I mean, you guys know that. Neither one's preferable, but it happens. And you deal with it when it happens.
Yeah, and some sellers, like relocation company sellers, won't allow them anyway.
Mm-hmm.
So, you know, just keep in mind if you're representing a buyer who might be in that kind of a situation, you know, keep in mind that not all sellers will accept a pre or a post occupancy.
Any questions on this topic before we move on, or any other comments from the panel?
Gail, with you speaking over there, banks probably don't want to hear anything about it. The bottom line is, don't look for the bank to give you direction, because they don't even want to know about it. I'm not saying it's improper. It's just they know the consequences if it's a post-occupancy. It's probably not prohibited unless it's more than 60 days in length. I think is usually when the occupancy of the new owner is required. So it's not prohibited, but still it's a stinky thing that banks don't like to
And muddy the waters.
muddy the water. I don't know. Okay.
Margie?
Sorry.
Okay.
That's why we're here.
The board doesn't have a form. The board has never had a form, a pre or a post form. Brokers use what they've had in their office. So there won't be a universal form if brokers are using it in their office. And what the board is doing is in the contingencies list, it's at the end of the contingencies list, it says pre or post occupancy addendum attached. They just removed that from that contingencies list. And
Even Foster had a form.
you're gonna make me say that out loud.
I've read it one time, probably.
Yeah.
One time, and I thought it was extremely even-handed, made a lot of sense, and is still the way to go if you're gonna have one. Because you don't wanna muddy it or get it too complicated.
Well, it is, Dave, and I do agree. I think ours is a good one. But what I'll tell you is that for brokers, how many brokers in the room? Raise your hand. Help me out, okay? It's, yeah, one out of every two comes back to the broker's desk and somebody's unhappy. And very frankly, I've not had any in the last 4 years, because we won't hold the money if there's money held anyway. You guys are holding the money. And so that's part of how the massage on it all has come up. And I will tell you, our Northern Virginia brethren, okay, will not even use a form that a broker signs, because there isn't a broker in Northern Virginia that will sign any of those forms. I'm done.
As an agent, the hardest part about the form is when we're working with our clients, let's just say it's a seller and they're doing a post occupancy, is explaining to the seller that they have to pay rent on a house that they own. I mean, they don't own it anymore, but that, and I think maybe having you all as a buffer, as the messenger for that, is maybe the helpfulness of this, because I think what happens is, you know, the buyer doesn't want to pay rent. They just think it's terrible that they're going to pay $50, $60 a day, you know, to live in the house. But honestly, there has to be some type of money, and I think that's the big thing. So I think it's a helpful thing with you all maybe being the buffer and letting the buyer and the seller work this out, because the agent is so involved in it that it's hard for us to get that message across, because we've been with these people for the last 60 days.
And I don't think we have any qualms explaining, here's what this is, here's how this works, here's why you need to do this. If somebody called and said, I'd like to do a pre-occupancy agreement, I would say, I'd like to tell you that I think that's a bad idea. I'm always gonna be straightforward with people. I understand there's things that you can't work around. There's things that you're gonna have to do to get this thing to the table. I'm gonna lay out everything. Here's what this is. Here's how this might work. Here's issues that could potentially arise if you do this pre or post occupancy. I'm happy to explain that to anybody. I just think, and I'm happy to say, here's why you should pay rent. You don't own it anymore. If you don't want to pay rent for a week, get out. So we're happy to explain things to people.
I think the summation is really clear. It starts with you guys. You need to really, when you list it, when you find the buyer, beat into their heads. We don't want pre-occupancies. We don't want post-occupancies. Guys, you got to work hard. Inevitably, 50% turn out to be a mess for somebody.
Yeah.
And no one wants a mess. Buyer, seller, a broker, lawyer, anybody.
Okay, thank you. So we're gonna move on and throw this one out to Matt. And he's gonna talk about the attorney-held earnest money deposits.
Okay, yeah, so I would go ahead and say, I probably shouldn't put a percentage on it, but more and more we're holding EMVs in, I'd say, most situations at this point.
Yeah.
That's fine, we're happy to do it, not a problem. Standard procedures, we prefer to get a check from the client. Some clients want to wire us money, we can work around that if we need to. Obviously, we hold it in a separate escrow account, we keep all the deposits. I think the problem comes to, when a deal's dead, can you hold this deposit for a next contract? Yeah, we can do that. I think the crux of the problem is, I'm not releasing a deposit to anybody Dave's not releasing a deposit to anybody. I don't think Kim's friend's gonna release a deposit to anybody until we get a fully signed release from both parties that tells us exactly what we are to do with that money. I'm not negotiating this for anybody. I'm not, we're not a judge. We're representing both sides of this transaction. I can't say, no, this person should get the deposit, no, this person should get the deposit. We will release the funds where we're to release the funds when we get the fully signed, executed release of the contract. I'm not the judge and jury. Well, they didn't, time was of the essence. Time wasn't of the essence. I'm not getting in all that. You tell me where I'm sending my $500 or $1,000, we're happy to do that. Obviously, if you have questions, we can provide some sort of guidance, but we can't really put ourselves in the middle of that, particularly if both the buyer and the seller are hard-headed about it, and say, no, it's my fault. If somebody calls the office, there's obviously we'll tell them to get a lawyer or, talk to her. But guys, most of the time it's $1,000 at most. It's, in the grand scheme of things, just, I don't know, split it. I don't care what you do with it. Just, we can't just say, oh, we have a buyer signed release. I literally have a file that I've had on my desk for probably 18 months where I don't have a signed release contract and they won't agree on who I'm releasing it to. I have $500 in escrow. So it's one of those things that it's a practical matter. I think 90% of deals, probably more than that, when they fall apart, everybody agrees to just release the EMD to whoever. I mean, I don't think it's usually a massive issue on who to release the EMD to. Maybe it is. You guys probably deal with that more than we do, but we cannot release an EMD until we're basically explicitly told where to release it.
Comments on that from either Dave or Kim?
No, he articulated
Yes.
it very well.
Questions or comments?
I think one thing when you, if indeed you're gonna have, whether it's with your, if the deposit's given to you or to the to the lawyer. I mean, we get checks where I'm not so sure that people even understand how to write checks. And I'm not a very good speller, but, and then we get checks that the buyer's name is Jane Doe, and the check at the top is from Johnny, whoever. And then Gale's Bank says, let's see the deposit, evidence of the deposit, and you can't even connect the dots based on names. So I guess if people have had checks for a long time, so maybe their names have changed and stuff, so they need to really make sure their check, you can doctor up a check, you can scratch your name out and print your new name, but they should have some semblance with the name that's on the contract. It should, I mean, because we'll get them in the mail, and it won't even, on the memo part, it won't say the address of the property. It'll have a person's name that matches nothing that we have. And I set these checks in a holding tank. And I mean, I've had some that are still there, but I don't know. I think, and this may all change, this whole deposits may slow down. I think trying to beat people, because there's so many people trying to buy one piece of property, that I think I'm having agents tell this person, send me a check, and they never ever even get the contract.
Well, and I think, and like Dave said, if there's a lender involved, they're probably gonna wanna see that EMD come from your personal bank account. Don't have mom send in a check, don't have grandma send in a check, don't have your cousin's girlfriend send in a check. You need to send in the check.
So this begs the question, I'm out of curiosity, because I don't understand how all that, I know how it works on the real estate office side, how the EMD is handled, but if you're holding money in a trust account for a transaction, who, because I just heard you say you've got checks, you don't know what about anything. So who's monitoring that money? Okay, I mean, I completely trust you, obviously, but it's a curiosity out there, you just raised that and I was like.
Well, the money that I get that I cannot identify with, I don't even consider it escrow money yet. It's no man's land money.
Oh, okay.
Until it's deposited and I can connect the dots is when it becomes mine. I mean, I could as easily just shred those checks right now. But I kind of hold them, just wondering if I think I've got 3 that I've been holding checks and I don't have contracts for 10 days.
Yeah. So the advice would be, if you're in a multiple offer situation as the buyer's representative, you should not even talk about the EMD until you're a fully ratified contract, and now you're sending over the EMD instead,
Or
everybody
send
just
us-
sending
even
your
if you
money.
want to send us an unratified contract, just give me something to connect the dots with.
First page.
Yeah, first page of the contract would be enough so I can connect the dots.
What's the responsibility of the buyer's agent to make sure that that EMD check, again, that's part of our job, is to make
Right.
sure that the EMD check is properly filled out with the proper address on it, the proper person on it.
Yeah.
And if I take an EMD, I don't have my clients send it. I have them send it to me, or I get it in my hand and I bring it up to their office.
Yeah.
That's
Yeah,
what
And
it
that
is.
way I know exactly where it is, who got it, and then I get a copy of it, or they email me a copy of it, and then we don't have any problems, send it to the bank, you know.
Yeah, now our firm does request that we have an earnest money deposit agreement
Mhm.
that we request the parties sign. So, you know, if you want us to hold an earnest money deposit, because we're not a party to the contract,
Right.
we ask that they sign this separate agreement.
Okay, anything else on EMDs? Sure.
So I had a purchase transaction last year. This was in Washington County, Maryland. And the contract comes through and there's a screenshot of a Venmo transfer. Honest to God. So I called the customer. I said, I'm going through here. We're doing a loan application. I'm like, okay, what is the screenshot of a Venmo transfer? Oh, well, my sister wrote the check for the EMD. So now it becomes a gift. So,
Right.
Yeah.
so,
Yep.
but I paid her back with the Venmo. I'm like, you're 55 years old. You don't have checks.
Well,
No, you can't.
I was gonna mention, with some of the younger buyers, like 27 and under, they have
They
not,
don't have
they don't
checks.
have a check. And if we do not, as their buyer's agent, let them know, this can't come from mom, it's better to get a cashier's check and you have to show proof of funds to the bank. But in this market where we're writing these offers quickly, because there's a deadline of tomorrow, they don't have a check. And they just go and get mom to write one, and then mom sends it to Dave, and now, you don't have any correlation. So I think it's really important that we as realtors let them know the importance of the funds having to come from their bank in some form or fashion.
I'd like to think I'm not that old yet. Get checks. I have a checkbook that sits in a drawer that I don't ever use, but get some checks.
But it's only gonna get worse, like
Or the
our
bank
kids
can
now can't, they're not even learning how to sign their name,
Or
how will they
or
sign their name?
figure out a way that you can make sure that you can transfer somebody money easily. Not do you have PayPal? Can I like Venmo you my EMD? Do you take a credit card? No. Like if you're showing a buyer a house, like Monica said, how are you? Okay, you're not gonna be able to PayPal Kim or Dave your EMD or whoever. Do you have a way that you can at least, can a bank send a check? Can you wire out an account, figure that out?
Yeah, wire out, because keep in mind, due to fraud prevention, most of the escrow accounts have an ACH block. So they can't ACH the funds.
And we have, sometimes our account has trouble keeping track of ACHs, so we pretty much tell people we need you to wire us funds. But at least, you can't use a credit card for your closing costs, okay?
No,
Like,
because
that's-
all of
that's
our
not-
accounts
that's not
have
gonna work.
ACH blocks, because we had somebody hack into one of our accounts using the ACH. So no more ACHs. Because it's a fraud prevention, unfortunately.
So let's move on to Dave, who's gonna talk about something we haven't heard about for a while, but it is coming up more, and that would be the 1031 exchange.
Well, a 1031 exchange is simply somebody that's owned real estate for a time period that has a basis that is significant, should be significantly lower than what the sales price is going to be. And that entity or individual is going to experience a capital gains that might be a little harsh on their pocketbook. And if they're inclined to want to be in the same type of industry or business or real estate that they were before, they can do a like kind exchange. So if have an apartment complex and you bought it 30 years ago and your base is 100,000 and now you can sell it for $1 million and you have a $900,000 capital gain, you can defer that capital gain by using a like-kind exchange. You need an intermediary conducts the escrow part of that, where they accept the money from the settlement and the seller never receives the money in kind. They find another property within a certain time limit, and then the intermediary escrow agent then transmits that money to the next closing, to that closing attorney, who now they have a new place for, they take that $1 million, put it over here for $1 million. They've avoided any capital gain, but their basis in the new property is still the low basis. They carry the low basis. So at some point in time, short of just dying, they're going to pay a gain at some point unless the laws change. Again, when you do these things, you're trying to predict the future. I think your job as a good agent is to recognize when you may want to say, have you ever considered a 1031 exchange? I'm not a pro, call your accountant, but maybe you want to consider that. If you're dealing with residential homes where the people have owned them as their primary residence 2 of the last 5 years, then even contemplating a like-kind exchange would be a mighty stupid thing to even say to them. Okay, so just remember the difference. If you are in your house 2 of the last 5 years as a primary residence, you didn't use it for an office, you didn't rent it, you didn't do anything to make it commercial, then you're exempt from taxes 100%, so long as a single person nets less than $250 and a married couple nets less than $500,000. And around here with the sales prices, it's pretty much impossible to exceed either one of those. So if you're dealing with residential, it's kind of a moot issue. But if you're dealing with somebody that is a second home, somebody that is Airbnbs are going crazy, big time, and I'm sure some of these things, maybe somebody bought it rather cheap. It's just good professional knowledge to say there's an animal out there called a like-kind exchange. Maybe you want to investigate it. And of course, they're going to look at you and say, tell me more, and say, that's not my gig, nor is it the 3 of us. It's not our gigs either, guys. Somebody calls me about it, I'll say, call this guy I've got. His name is Ed Moran, his brother is Bill, Cindy Dove. I've worked with these guys for 30 years. They're trustworthy, they're smart, they do it every day. Call them. They're probably going to tell you, call your accountant to work collaboratively with me anyhow. But again, I think it's just when you're taking a listing, it's something to know in your repertoire of knowledge that, hey, I've got a guy here. I just did an apartment. I'm going to list an apartment. Do you have an accountant? Maybe talk to your accountant. You might want to talk about a like-kind exchange. You're just sharing knowledge you have, which has value to that person. And there's some people, if you're not an agent that has that knowledge, this guy might, guys, I've sat in closings. My memory comes back when I was doing this. I've literally sat in closings, and Mr. or Mrs. X is selling an apartment complex, and he says, Dave, I want you to hold my money until I find my next place. I said, what for? It ain't going to do you no good. Well, if you don't give me the money, I don't have to pay taxes. No, that's not how it works. So that they need to know right at the top. And the problem is, you get to the table and make that comment, and all eyes are, they're not going to change. It's going to happen. The closing is going to happen. And now this guy's lost his opportunity, or she's lost her opportunity to do something they really wanted to do. And they probably read about it in USA Magazine one time or something, and it was vague enough, or they Googled it and they say, you just do that at closing. So they trust Kim or Matt or I to just do it at the table. This is something that has to be planned out and disclosed to the buyer. It's nothing hard about it. It's not difficult, but it's got to be done at the beginning so that you don't let it fall through the cracks. But again, it's something you guys can use in your knowledge repertoire to just, hey, this is a commercial building, this is an apartment, this is an Airbnb. by the way, are you familiar with like-kind exchanges? No, tell me more. I can tell you enough to call your accountant to see if they think you're a good right target for that. And what you could add to it too is, this is what I think you're gonna sell it for, because that's what the accountant's gonna say. What are you gonna sell it for? And then the accountant knows the basis, and then they can start collaborating on net gain and potential taxes. That's pretty much, I think.
Yeah. The only thing I would add is that, as Dave said, it's got to be in the beginning, because there are addendums to the contract for both a 1031 buy and a 1031 sale that have to be there or it won't qualify. So if you think you have a buyer who is buying a 1031, make sure you know that information in advance. If you have a seller that may qualify, get them with their accountant, and most of the underwriters also have 1031 intermediaries that are affiliated with the title underwriters. So we can put you in touch with a 1031 intermediary if your client wants to go that route, and their CPA won't act as one. So that's a possibility, but there are things that have to be signed and addendums to the contract that have to be signed in order for the client to successfully complete a 1031 exchange. So just keep that in the back of your head.
And you may have buyers that come to you saying, I've sold and I have money in a like-kind exchange holding tank, and I have $900,000. Go help me find property, and I need to find it in 45 days, or there's a time gap thing in there. But Matt has a client out of California that has like-kind exchange money that he's done about 5 or 6.
Yeah, just
In
buy
West Virginia.
And he's got, I don't know how much money he's got in his account, it's none of my business, but last year he bought 2, this year he's bought 2. And we just keep, and then, we have to work with the exchange company. Settlement statement has to appear a certain way, there's documents they need to sign.
But that fits into what Kim just said, you need to be early on both sides of that fence.
Right.
Any questions about the life exchange from anyone? Alrighty, so our next topic is, when your seller or buyer is either an entity or it's a trust, and Kim is going to talk a little bit about that to start us off.
Okay, if you have a property in an entity or a trust, you need to get with the settlement attorney early on to make sure that entity or trust has all of the documentation they need, so that we can identify who actually has to sign things. Okay, I had a commercial deal that fell apart because the entity documents say that there are 2 managers. One of the 2 managers did a unilateral change in those entity documents saying she's the only one. That doesn't fly. The other manager is her now ex-husband, who has claimed in court cases that he owns a half interest in everything. Guess what? So in order for you to take a good listing, trust documents, are we dealing with the original trustee, or has the original trustee been replaced due to either death or incompetence, or they just resigned and are letting somebody else as successor trustee take over? So whether you're an LLC, a corporation, a partnership, a trust, any of those entities, we have to get the documentation to make sure that, 1, the entity has the authority to buy or sell, whichever it's doing. 2, to figure out who in that entity is going to be the person or persons who need to be present at closing or to sign all the documents. There is a professional development course that I did back in the fall that's on the YouTube channel that explains a little bit more about that in detail. So if you would like to enhance your education in that area, you can always go on the YouTube channel. But that anytime you're dealing with something other than an individual, you need to contact your settlement attorney and make sure that, we get the proper documents to figure out, who has the authority to actually sign for that entity.
Just to touch on that, if there's a trust involved, I'm gonna need to at least see what's called a certification of trust. It shows what the trustee's powers are. Your client may not want to give it to me. I have to have it. West Virginia law requires us to prepare a memorandum of trust. It's, sometimes the client, that's fine, I'll read through it, it's whatever their comfort level is. I have to have at least something that dictates what the trustee's powers are. I have to reiterate that on documentation, you reiterate that in our deed. They need to know that upfront. I'd like to get it as soon as the contract comes in, because then it gives me time to review it and prepare. I don't want it to be,
Exactly.
oh, can I just bring it to closing? Sure,
No.
it's just an hour's worth of work that I'm gonna have to do while you're sitting at the table. No, I need it. I need it beforehand. I need to be prepared if you're gonna trust. Yes, Carol, sorry.
No, I want you to finish. My question is, as a listing agent, should we know that on how to legally list the property? I mean, should we have at least the front page of the trust to know what the legal name of the seller is?
Yeah,
Because isn't the trust the seller?
yes. So whoever's the trustee of the trust is technically the seller. More often than not, the deed will have the proper name of the trust, more often than not always. It would be good to at least confirm, hey, can I see your certification of trust, your trust? Let me confirm the name, It could be Matt Leonard, trustee of the Leonard Family Revocable Trust, blah, 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 blah.
Right.
Or it could be, Dave Pill could be the trustee of the Matt Leonard Revocable Trust, whatever. You want to have your ducks in a row. It makes it a lot easier moving forward towards the transaction.
I would suggest on that note, as soon as you take the listing, you go ahead and get the trust reviewed, so that if you need to have somebody different sign your listing agreement, then you can go back and make that correction, and as far in advance as possible, and you don't get all the way to the settlement table and discover that the person who signed your listing agreement had no authority to do so.
I think even if you have not a trust, but an LLC.
Yep,
um,
same thing.
You need to be doing that. We had one, it turned out that the LLC was a term limit LLC. They didn't realize that it had expired. So in the process of selling the property, we discovered that the entity that owned the property no longer existed.
Right.
And we had to jump through a bunch of hoops, because we had to redo a new LLC with the same partners and same members and everything before we could even get the contract to sell, because there was no entity that could sign the contract.
And I have had any number of entities, LLCs, corporations, where they have had to put themselves back in good standing before they have authority to sell as well. So if they haven't filed all their personal property tax returns with the West Virginia Secretary of State and paid all their fees, and they're no longer in good standing, they technically don't have the authority to buy or sell the property.
And if it's a mortgage, the underwriter's gonna wanna ask for these documents as well, so
Sure.
always gonna have them.
Yeah.
Any other questions or comments on this topic?
Yeah, Gail, I think for listing purposes, you get into an area that sometimes gets extremely complicated for you. And I think your duty is to seek out within reason the power and authority of the person that came to you that says, we're going to sell this. Now, it doesn't mean you're going to be perfect, because it gets complicated. But if the person's name doesn't match up with the tax bill, if the person's name doesn't match up with the most recent deed that you can find, you have a duty to dig a little bit deeper into those things. But if there's some logical basis to connect the dots for power and authority. I don't think you have a duty to hire a lawyer to go dig at that stage, but just don't wing it either. The domestic relations situation there, you know, have a nice communication with when you're listing the house. So what gives you the power and authority to sell this? They might say, well, I have possession of the house. Well, good, but this is my job, just to make sure that we're not going to miss something. The one that's probably could be the most common right now is decedents, and whether somebody passes away with a will or without a will. And so if somebody says, we're going to sell mom's house because mom passed away, I think your due diligence is, did they have a will or did they not have a will? That's an easy question and one within the knowledge that you guys should contain. If it was with a will, there's a substantially good chance anymore that it's going to have power of sale for the executor or executrix in the will. So I'm not so sure you have to dig deeper there. If it's a sale by an intestate decedent, somebody that passed away without a will, and the law is all heirs have to cooperate to participate in that sale. And sometimes you run into a delay or a complete aborted transfer just because the heirs really aren't engaged in.
The first question, just to briefly touch on that, because I think we're supposed to talk about that maybe down the road too.
Yeah,
Sorry.
that's okay.
That's probably my error not knowing the itinerary.
That's okay.
That was your topic anyway.
If, well, good, so you need to give me the funds. If you have a seller that's an estate, have you probated the estate? Have you went to the fiduciary's office to probate the estate? If not, I don't know who's supposed to sell it at all. And then guess, if you haven't started that ball rolling, Dave or Kim or somebody's gonna have to hold your money for a while too. Understand that if you haven't started this probate process, the lawyer might be holding your check for 3, 4, 5 months, and you might not be to it. So all those things out there, because I don't like to get to 2 days before closing and I say, by the way, I gotta hold your money another 45 days. Okay, and that's a nice surprise, but you know, things happen. I get everybody's busy. Everybody's got a lot of balls rolling, but that's just my brief follow-up on it.
I've actually had 2 closings this year that we didn't find out till the week of closing that there was no estate filed. One closed 60 days later, the other one has not closed, and that contract was probably back in March. So, yeah, it just, it's better to find out way sooner than later on that.
Right. I have a question for Matt. I'm gonna put you in the way back
Okay.
machine. Your way back machine's really short. We had a transaction with you this about a month ago that we dealt with a durable power of attorney.
Okay.
And do you remember it was 10 years old? And the
Yes.
title insurance people didn't want to take it. I'm old, I've been around a long time. I was like, what? Can you talk about that?
And I don't remember, and Dave, do you have a better memory on that than me? 'Cause I don't
Gravel
have a
path.
specific memory.
Gravel path. And that is Spring Farm.
Well, I mean, the older a power of attorney is, the less confidence that we all have in the situation. So it depends a lot on the person that's granted the power of attorney. Where are they at now? Why can't they participate? Who is this person that is participating for them? There's a lot of questions. I mean, generally speaking, 10 years probably is still inside the bucket of acceptability, so long as there's a rational basis for the use of the power of attorney.
You got what you guys did. You were superb. Is that the Mr. Seller was in the hospital. And you ended up getting Ms. Seller, who was the durable power of attorney, to go to the doctor and certify that he could not sign and she signed.
Oh, okay, that makes sense.
So you really did fix it. But that made me question, if you have a durable power of attorney that is that old, should you do it again?
I mean, generally, so, like Dave said.
Well, I mean, you
situational
still have to
basis.
be competent to redo one.
Yeah, so if
So
that person,
that's the facts and circumstances. This person that signed this 10 years ago, what's their mental state today? Why can't they be a participant? They're in a nursing home, they don't know X from Y and Z. And sometimes we might accept that. In Matt's case here, our title company might have just saw, the power of attorney may have been a little bit of a weakly written one too. I don't know. In other words, if you see Kim's name on a power of attorney and we send it to one of our title insurance people, they're gonna say, great. You know, Jimmy Steptoe stuff. Jimmy's been on 10 or 11 years. If I got a power of attorney from Jimmy Steptoe and I send it down to Old Republic or First American, and I'm gonna say, remember Jimmy Steptoe was a pillar of our community, they're gonna bless it.
Yeah.
So there probably was a little wrinkle there that just made us a little bit nervous.
Well, it wasn't you guys, I think it was your title insurance.
Right.
Right, and our title insurance underwriters, each of them have a checklist of stuff we have to go through with a power of attorney. So please do not bring a power of attorney to the settlement.
Yeah.
And the moral
Amen.
of the story was you didn't get the durable power of attorney until about 5 days in advance of closing, because that's when Mr. Sully went off.
Yep, and sometimes, we'll do whatever we can do to make the transaction happen.
It was a lot of things I learned that day, I can tell you.
It's just, if we can have them in advance, great. You try to avoid surprises. Surprises always happen. I had one last week. Person called me Thursday. It was supposed to close Friday and says, my wife can't come. I said, well, why can't your wife? I want to do a power of attorney. Like, closes tomorrow and you're buying like with a lender. That's probably not happening. He goes, why can't your wife come? Oh, she just didn't want to drive up. I'm like, no. We will see you both tomorrow at 11 o'clock. That's a surprise. I maybe could have worked around it. I don't know, probably not. By the time I had prepared a power of attorney, had the bank review it, she'd have had to have it signed and notarized anyway. That's, but life gets complicated. Things happen. We'll do what we can do to make things work. But it's not like, oh, you know what? Hey, you could probably just sign by our power of attorney. That'd be cool. No, if you can be here, we need you here.
And by the way, it's all a matter of, as Dave said, circumstances. I had one where the power of attorney was considered void because the attorney in fact had filed a lawsuit for guardianship and conservatorship, claiming the person was incompetent. And then got them to sign a power of attorney and this lawsuit. No, you can't have it both ways. You said they were incompetent, guess what? The power of attorney is no good because they're presumed now to have been incompetent because you said they were. So, like I said, powers of attorney are the title insurance underwriters' #1 cause for claims. So they don't like them. And that goes back to why the title underwriter probably didn't like that 10-year-old durable power of attorney. They don't like them. They give us a big long checklist of things we have to do. If possible, we have to talk to the principal. Why aren't you here? Did you grant that person a power of attorney? Are you aware that they're using it to sell your house? So there are things we have to do to make that power of attorney part of an insurable transaction. So therefore, if you know that there might need to be a power of attorney, please let us know as far in advance as possible so that the arrangements can be made and the hoops can be jumped through. Okay? That way we won't get to the settlement table and not be able to close.
Our next topic was power of attorneys. I think you did cover that, but is there anything else that you want to say
I
on
would
that?
say too, when your clients are using a power of attorney, and if they've used one for 9 or 10 years, they got so accustomed to being able to use it, go to the bank and do the banking, write Social Security and get information. And then all of a sudden they get an obstructionist like us. But there's a significant difference between personal property transactions and real estate transaction. And there's a tremendous distinction. And when you're dealing with a power of attorney person, again, that's okay. If they give you a power of attorney, mom gave you a power of attorney, and you want to do the listing, that you've probably done your due diligence, but immediately have them, whoever the closing attorney is, reach out to that closing attorney, say, can we, and I'm telling you, we do get good cooperation in the power of attorney arena. I'll have, as a matter of fact, I had a closing the other day and they called about a week before closing and the agent did and said, hey, now remember we're using a power of attorney. I said, well, send it to me so I can review it. They said, Dave, we sent it to you a month ago. You already blessed it. I said, okay, fair enough. But no, you do a good job And sometimes you'll get your client will be offended because they've been able to use it so easily for so long. So, that all these are delicate paths to communication with our clients and consumers in these transactions, because their expectations may be a little different than our knowledge.
One thing on that is we will need an original power of attorney, sorry, Ken. We will need an original power of attorney. It will have to be recorded at the courthouse. We have clients that are very hesitant to give up their original power of attorney. I get that. I don't have any work around it. If they're local and they want to drive it over to the Berkeley County Courthouse and walk into the county clerk's office and record it and they'll hand it right back to them, that's fine and dandy. That's great. It's like $12, okay? If not, they're gonna have to hand it over to me and trust that we'll get it done and get it back to them. We have to have an original power of attorney to get to the finish line. No ifs, ands, or buts about it. Very few attorneys around here that prepare powers of attorney seem to go ahead and record them. There's probably various reasons for that, but at some point, it's gonna need to get recorded for the real estate transaction to get finished.
Just about to mention that, so it's pretty good.
We're on the same page.
Questions, anybody on any of that? Okay. So the next one we touched a little bit about was estates, but also Dave is gonna start us off by talking a little bit about foreign estates as well.
What kind of estate?
Foreign estates.
You mean like ancillary administration? Is that what we're talking about? Well, there's so many definitions of foreign anymore. So, yeah. So, I mean, if somebody passes away in another jurisdiction and they probate their estate in Maryland or Pennsylvania or whatever, but they happen to own real estate in West Virginia, there still has to be a short type of probate done called an ancillary administration, where the will is sent to the county and there has to be an executor or administrator qualified in West Virginia, so that we can connect the dots as to the person's death and the powers and authorities of the party that would be executing the deed or executing your contract as well. So the ancillary administration is not the primary administration, but it's a secondary one that has to. So if somebody from Maryland says, we've already probated the estate and everything's good, and here's the will, you can say, did you do a probate in the county in which this property is being sold? Morgan County, Berkeley County, Hampshire, Jefferson, wherever. Did you take the steps to do? You don't even have to call it an ancillary administration or probate, but just say, did you probate in the county? Well, I don't need to. That they died in Montgomery County, Maryland. But you have to be able to connect the dots for history's sake, so that we can see that Jane passed away in Maryland, but here's her will registered in the location where the real estate is at, so that you can always connect the dots down the line. So that's the spirit and need of an ancillary administration. It also will have some sort of short-term claim period with it too, where we may have to hold some money back, pending somebody local saying, well, I worked on his car every time he came up here to the Woods Resort, and he's never paid me, $17,000. So I want to put a claim in against that estate here in Berkeley County, West Virginia. So there's still an opportunity through an ancillary administration for potential people who owe money to, or maybe they went to City Hospital on their last, go around. And so it's important that the ancillary be done, or we're not going to get to the finish line again. And so if somebody tells you it's been probated, make sure you dig deeper. Was it probated in our location here in where the real estate is, where the location of the real estate is? Yes.
I understand where you said that's across states. Is that the same within different counties within the same state too?
Yeah.
So it's like,
I don't do that. If there's a probate in Putnam County, I'll reference Putnam County. Now, I'm probably skirting a little bit of local abilities to put claims in, but I feel like if it's under the West Virginia umbrella, I'm probably okay with it.
Yeah, we'll make sure that we would need to know what county it was probated in so that we can get copies of that probate paperwork so that we can properly reference it in our deed.
Yeah, and I, you know, that, and I use like Putnam and Berkeley, but the truth is, you might have the decedent right there on the Hedgesville border or the
Yeah.
Kearneysville border, and they've got property in both jurisdictions. I've honored that. I guess I have to run that by a title company. I mean, could somebody say in Berkeley County that they weren't aware that this person passed away and there had to be, and they expected the notices to be published? We probably need to look at the circumstances too. In other words, when I look at that probate in Jefferson County, if I saw a whole bunch of claims, saw a whole bunch of issues, I might be a little more cautious. So there's risk management that the three of us do every day on these things.
I'd
too.
back you up with that though, because if they pass away in Berkeley, they probably run the notices in the journal, which most people that read a paper in Morgan County and Jefferson County are probably reading the journal.
Yeah.
Pass away in Morgan, they might be publishing that in the Morgan Messenger. I don't know. I doubt anybody in Martinsburg, except my great grandma used to live on Raleigh Street, was reading the Morgan Messenger.
It would depend on where they publish.
I would feel, I just, again, like Dave said, it's a case by case basis. You get into what you're comfortable with, what you're not comfortable with. And you just kind of have to.
But if somebody said, well, they passed away in Kanawha County or Montague County, I would say, we'll go ahead and get the listing. Let's reach out to the closing attorney and see what they're comfortable with. But there's a chance we could skirt that one.
Thank you.
Good question.
Yes, sir.
You mentioned that there also would need to be a in-state executor. Are there individuals in the same as foreign corporations can have locals who serve as representatives? Or can the executor from Montgomery County, Maryland? I thought you said they had to be in West Virginia.
No,
No, they have to be appointed in West Virginia.
Okay, so it could still be the same executive.
Yes,
Okay.
it would be.
Preferable.
Yeah, it's preferable that it be the same executive.
Gotcha. Okay.
And at least the local courts, they really try to help out and
Yeah.
work with the foreign jurisdiction to get what they need. And so there's not a lot of obstructionists there too. So if the person will just cooperate, it should go rather smoothly, but it's a small effort. You got to put some time in it, but it's very manageable. And the local courts, the fiduciary courts are very engaging with it.
And up next is Kim to talk about legal names.
Legal names, especially those who are representing buyers. Please ask your buyers to put the name on the contract that appears on their photo ID. I have had 12 refinances in the past 2 weeks that couldn't go as scheduled. Now, we do a lot of Freedom Mortgage and Rocket Mortgage closings, but that couldn't go in the last couple of weeks because somebody took title as Roma Jones and her actual legal name is Jennifer Jones and Roma is a nickname. So she has no ID saying she's Roma. So we can't notarize Roma. Because there may be actually somebody out there who is Roma Jones. Please, 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 and especially with married couples. Once they've gotten married and they get their next ID, that's what their name is. Okay, unless they go through a name change. So if Jane Jones marries John Smith and her next ID says Jane Jones, she's still Jane Jones. If her next ID says Jane Smith, she's now Jane Smith. So please, 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 with your buyers, put the contract, the loan application, all of the documents in the name on the photo ID that is their legal name, so that when we get to the closing table, we don't have to go back to the lender and the title and redo all the documents in their legal name.
Yeah, I'm with Kim on that. I got an Uncle Buck. I don't think anybody knows his name's Richard. I got an Uncle Duty. I don't think anybody knows his name's Todd, so just ask.
Yeah.
Get a copy of the driver's license, guys.
Or at least look at it.
Yeah,
Yeah, but it's good for everybody. I mean, even for your safety, you never know a knucklehead out there. If you say, for purposes of writing a contract, guys, I will need to have your ID. And then you get the name. You get the name for the contract, because you get some strange looking names on these
When you get
contracts
some-
sometimes.
yeah. You might, like you said, you might have some fraud elimination.
Might help on fraud and stuff.
I just have one question, and this has to do with the listing. You have someone whose name is Sandra D. When they bought the property, okay? They get married, do a name change, whatever, and then they want to sell, but it's not been redeeded, it's still Sandra D. Now it's Sandra Jones. What is the legal name for the listing? I mean, I've always.
It would be Sandra Jones, formerly known as Sandra D.
Okay, so you need to put both names then on the list.
And advise them that they are gonna need to provide us with documentation for all the name changes.
Something to connect the dots.
Okay,
I mean, for my name, if I had taken taken title to a property in my maiden name, I would have to produce to get my driver's license, a marriage certificate, a divorce decree, and another marriage certificate. To go from my maiden name to my first married name to why I'm no longer him and my second married name. Okay?
oh, I get that.
People are gonna, we're going to need to connect the dots. If you took a name, you took title in a former name, we're gonna need to be able to say, this person is now this person.
Yeah, and it's helpful from a title perspective, because if you don't give us their old name, and like they're the only person on the contract, sometimes it's like, well, listen, this person doesn't own anything, help me out here. So it's just from a title perspective, it's helpful. It just saves you a little bit of time.
I write both last names on there. Like I had a client who's divorced, but she owned the house. And she's been remarried, so we just put, in tax records, her name was her divorce name, so.
Yeah.
We just put both names on, we put everybody's name on there.
Yeah, if you do an FKA,
Yeah.
then we know that this is her current legal name. And this is her married, because if we find another name in there, then we have to take the time to do judgment runs on the name that they weren't given. All right, because we have to do judgment runs on all the versions of the name that she's been since the time, or he, since the time they acquired the property in this name to the point where they're selling the property in that name. All right, so in order to avoid further delay, please give us all the versions of the name. So that we can do the judgment runs on all the versions of the name up front. Yes, Doug?
I get, and have over the years, individuals who are looking at purchasing rental properties,
Okay,
and it is not gonna be purchased in their name. They're
Okay.
filling out the offer
right,
in their name, of course, but they're going to form the LLC
right.
before it goes to closing or at some point immediately thereafter.
Mhm.
What kind of timeline do you need to see if you're going to get that actually titled, not in their name, but in the name of the LLC?
Depends on whether or not they're getting a loan. If they're paying cash, we just need it a couple of days ahead of time. We need to see, they have to have the LLC fully formed and get us paperwork a couple of days ahead of time so that we can properly prepare the document.
Yeah, I didn't mean to cut you off, I'm sorry. Out of courtesy, as far in advance as you can get me these things, I mean, I know everybody's busy. It's, and sometimes I might not be preparing this stuff till 2 days before closing, but a week, I don't know. It's just one of those things that I don't want to do it the day before closing if I don't have to. And it's something that shouldn't be, not ultra difficult to set up. So if you want to set your LLC up a week or two before closing, then that's preferable, I think, to everybody involved.
And just when you turn in the contract, let us know that it's gonna be in an LLC name so that, you know, we're not surprised a couple of days before closing.
The other, you actually put to be determined.
Yeah, but I've also seen people do a TBD when they're deciding whether or not to add their wife or their other, you know.
Yeah.
If you're adding another individual right before closing, then we come up against, we still have to run bankruptcy searches to make sure that person's not in bankruptcy, which would impact their authority to buy and things and borrow and things like that. So, you know, as soon as we can, we would like to know the names of our buyers. So we can do our due diligence and make sure that the title is clear on the buyer. Because if, you know, if you've got a buyer who has some IRS liens against them and they're not aware, and you don't get their name in time to search the IRS liens, and, you know, the moment they buy the property, there's $100,000 worth of judgments against it, they're not gonna be happy.
Okay, so we covered a lot of topics, but we also said we were gonna give you guys some time to come up with questions that weren't in our topics, or even if they were in our topics. So who has questions? Monica?
Matt,
Yes.
can you give a scenario dictating where time is of the essence is applicable versus a scenario where it may not be?
I can, kind of, so it's kind of muddy, right? So it's, I'm not gonna give you a clear answer, Monica, and I apologize. If time is of the essence, it's not like, if you don't meet the closing date, right? If your contract says September 30th, time is of the essence, in my opinion, you could still probably close October the 1st. Now, the lender's gonna wanna see an extension. I don't think that means October the 1st, the contract's necessarily dead. And we've had this recently, which is why you asked me. You know, would I maybe say October 15th, October 10th? You're getting into some issues. Time is not, if it's not of the essence, weeks, maybe a month. I don't know. It's one of those things that I think sometimes you just have to be upfront with your clients, and it can be difficult. Time is of the essence doesn't necessarily mean that the contract date's the drop dead date and you can just go ahead and form a new contract the next day. Kim might disagree with me.
I don't disagree with him, because a lot of the timeframes in the contract have built-in extensions. There's a built-in extension for a seller to clear title. There's usually a built-in extension for a buyer's loan as long as they do A, B, and C timely. And timely is one of those not easily defined phrases. So if you go into court, like he said, if you go into court and say, well, you know, the contract said that they had to have a loan approval by September 30th and they didn't get it until October 1st. Was that timely? And the court's probably gonna look at it and say, for real? So, you know, I'm with Matt that time is of the essence presupposes a timely response on the buyer's side to request from their lender, timely response from the seller's side to request from the title attorneys for documentation, things like that. And there are built-in extensions into the contract. So there again, you know, getting an actual contract extension might be advisable or necessary in some cases. I know on relocation transactions, relocation company won't approve my settlement statement for a date after the closing date unless there is a ratified extension. So, you know, on relocation cases or REO cases or stuff like that, where you have an entity seller or a big entity seller, then they want documentation of everything, every change. And usually won't approve the settlement statements until they get it. So,
I have a question. I don't know if you can answer this, one of you three can answer this or not, maybe our contract instructor could answer it.
Oh.
But a lot of times what the questions that I have from agents in my office is, so we got 10 days for the home inspection. It's the 12th day and I haven't gotten anything. What am I to assume? Time is of the essence is in the contract. So now, 2 days after the deadline of the 10th day, I suddenly get, a list of 27 things that need to be done based on the home inspection. In my opinion, the seller has they don't have to do it because you missed the deadline. And even though there's that 3 days, I didn't get that list of stuff within the 10-day time frame. Is that right? Time is of the essence? Now what do we do?
That's a fabulous question.
It happens a lot.
It does
Yeah, I mean,
happen a
that's a
lot,
real
and I think
scenario, but
each one is so unique that the true answer is found through a judge. And unfortunately, that's expensive and time consuming. You guys experienced a time consuming, expensive one. So the shame of it is there's really not an answer. And hindsight is almost 20/20 vision with time is of the essence. Prep your seller and your buyer that, look, what they started out with is, guys, use a reasonable basis.
Right.
And if we want to go back to the old school time is of the essence, which wasn't about, you remember when it wasn't about inspections and stuff, it was simply the finish line, was the old fashioned time is the essence. And I've always said, if you really want that to be time is the essence, you do an addendum that says, this must close on January 1st, 2022. If it does not settle on that date, this contract is terminated, regardless of any other terms of this contract. And that's about the only, and it takes a judge to ultimately say, so that we're dealing in areas where, and right now that's probably coming up some too, because you got sellers that they look in the rear view mirror and they say, I can get $15,000 more now, and this guy's dragging his feet.
Yeah.
When the dust settles and things go back to normal, these issues sometimes don't surface.
yeah, and what I would suggest as for buyer's agents is if you're having trouble getting a home inspection scheduled, which is a possibility, within that time frame, get an extension on it. You know, the
That's
answer
your easy
is,
answer. That's
the
the
answer
but usually not.
is to, in advance, take care of the problem by getting an extension on your home inspection. Because you're having trouble finding a home inspector that you can get scheduled within the window. Because you still, just because he goes out on the 10th day, doesn't mean you're gonna get his report on the 10th day and have your seller have time to go through his report on the 10th day and give an addendum to the buyer's agent on the 10th day. So, go ahead and in advance say, we need an extension because, we're having trouble getting a home inspector scheduled. We've got one scheduled for X date and we need, a day or two to review it. So.
I'm gonna give the instructor answer,
Okay.
okay? My instructor answer is, Ms. Agent, Mr. Agent, it is your seller's answer that makes a difference. I don't much care what our opinion is, I'm sorry, but I don't. Your seller needs to decide, am I gonna work that list? Do I wanna do that or do I not? And if the seller decides they're not gonna work that list, then they send back a release and say, see ya. Okay? Or they say, I'm gonna try to hold you to the contract. But the reality is, I think that's the way we have to deal with it.
Yeah.
Because we can't make that decision for the consumer. And if a judge is the only person that is the ultimate answer, is any of them gonna, do they wanna do that? Okay? And we hope our answer is no, they don't wanna do that.
Right.
And so that's at least, and I have a real good example too. We had, and it is rampant, and I know you guys in this room know this. that as buyers are bargaining with sellers in multiple offer situations, they're saying, I'm not doing a home inspection, I'm not doing a home inspection. And then after ratification, within 3 days, they get a home inspection request. Okay? And very frankly, it makes me nervous when anybody refuses to let a buyer do a home inspection. But I have absolutely advised my folks to go back to their seller and say, here's what you ratified, here's what they've asked. It is absolutely your decision, Mr. Seller, do you want to let this happen? And then the seller has taken has taken the responsibility for how does that play out. And I will tell you, we've had a couple instances where the seller said, yeah, I don't care. And we've had instances, and I'll tell you this, and I said to my agent, if the seller says no, have them sign the release right this second. And we sent the release back and said, the seller says, we ratified with you because you were not doing an inspection and we didn't have a list of work, and we'll release you and move on to the next people. And the buyer said, I don't need an inspection. But I do have a question. As I teach basic contract 101, historically, I have said, if you use time as of the essence, there's no real extension of the date, realizing that if you Google court cases online, there are lots of cases that are closing after the fact. Would it be fair to instruct that if you use time as of the essence, you maybe have some days, okay? If you take time as not of the essence, my friend Dave Pill gave me the soundbite that was reasonable time, probably a couple weeks is reasonable, but more than 30 days seems to be unreasonable. Does that still hold true?
I think it does.
Okay.
And Kim brought up a good point too. And we're talking as if we're in front of a judge right now
Exactly.
too. And so a judge is going to look at the time as essence right now and say, everybody in the world knows how busy it is. We know some people are fearful of COVID. We know that that maybe there wasn't even a meeting of the minds that this could actually be possible to do.
Yeah.
The window was too tight because you couldn't get. So, yeah, I mean, the reasonable, was there a meeting of the minds? You know, those are just all cliche things we learned in law.
So I still say what they
Hey, generally speaking, people engage in each other, wanting to get to the finish line as smoothly and as comfortably as possible. And that means tremendously good, true communication. Sometimes that communication is tough. You're going to tell them something that you don't want to tell them, but you might as well tell them. And as soon as I tell somebody something I know punches them in the gut, and I say, but I know the solution. And it may have some time to it, but we can get you to the finish line. Let's not panic. So you need to hit them in the gut, but then pull them back up. And that's what we do that on the mini.
So we're after 1. Maybe one last question if anybody has one. Okay, I think we're good. I really do want to thank Kimberly and Matt and Dave. Let's give them a big round of applause.
Yep, wrap up. Don't forget, the contract 101 class, September 20th, registration is open. 22nd annual membership, 12 to 2 at the Holiday Inn.